Welcome to the boot camp series. Today is boot camp day 6. The topic is going to be pre-authorization, medical necessity, and utilization review. We're going through the workers' compensation obstacle course here, and we just swung through the swing set obstacle, and now we're going to the climbing net. And with pre-authorization, medical necessity, and utilization review, we do not want you to fall through any of those pitfalls regarding providing treatment to our injured employees through this obstacle. So our learning objectives for today are: 1, determine what medical treatments out there require pre-authorization in the Texas workers' compensation system. And how do you request pre-authorization? Know those steps and how to find the steps. Understand if you do happen to get an adverse determination or what we call denial, how to appeal that pre-authorization denial. This is always of interest in the workers' compensation system. So today, let's talk pre-authorization. Before we get started, there's a disclaimer here, and that is that we do our best to provide education to system participants. That's the purpose of today's webinar and recording. But however, system participants, you guys out there listening, are responsible for knowing the laws and the rules. So if there ever were a dispute or a complaint, we're going to go back to the language of the law and the rules. So that will help resolve. So anyway, we are doing our best to show you where to find those citations and the rules during our presentation and with your handout on finding your resources on the workers' compensation website. An overview of what we're covering today. First of all, what is medical necessity? What determines medical necessity in the Texas workers' compensation system? Also, what are the medical services that require pre-authorization? And the utilization review process during pre-authorization. We'll talk about that. Also, during the appeal, the independent review process will be covered, and then also DWC resources. Let's talk medical necessity in workers' compensation. The first statute I want you to be familiar with is the umbrella statute. Covers all entitlement to medical benefits for an injured employee. That's Labor Code Section 408.021. And it says all healthcare reasonably required to do several things, and that is to cure and relieve the effects of the injury. And when we say injury, could be psychological, could be psychological trauma, could be physical trauma, could be a combination, anything related to the injury, could be an infection, that sort of thing. So all healthcare reasonably required to cure and relieve the effects of the compensable injury, and help the injured employee get better or recover, and help them get back to a productive role back in the workplace. So we want to enhance their ability to return or retain employment in the workers in Texas. So that's the entitlement to benefits. And notice in here, there's no cutoff for medical benefits. It doesn't say provide all healthcare reasonably required until we say it doesn't. There is no date of cutoff. So as long as it's reasonably required, then our injured employees are entitled to medical treatment. The next statute I would go over is the Labor Code 401.011, and that's our list of definitions in the workers' compensation system. Item number 22 is healthcare reasonably required. This is the definition of healthcare reasonably required. That is, the healthcare has to be clinically appropriate. It has to be effective for that particular injury, for that injured employee's condition. And it has to be best practices consistent with evidence-based medicine. And when we say evidence-based medicine, that's scientifically valid information that's out there on treatment recommendations. And if evidence is not available, there are conditions and situations where evidence is not available. Maybe it's new emerging condition or situation. It must be, the treatment must be consistent with generally accepted standards of medical practice recognized in our medical community. So those are some of the criteria for what healthcare reasonably required means. That's the definition from our statute The legislature writes the statute, we write the rules. The next one to understand about medical necessity and workers' comp is 413.017, and that is talking about the presumption of reasonableness. That means if you're following these criteria, it is presumed to be medically necessary in our system. You have the presumption. The other side would have to overcome with more evidence to determine that it's not medically necessary. So you have the presumption of reasonableness if you're following medical services consistent with medical policies. We call those treatment guidelines. There are treatment guidelines in the workers' compensation system or medical services that the insurance carrier has approved through utilization review. We're going to talk more about what utilization review is. So you're consistent with the medical treatment guideline and you say you've gotten pre-authorization from the carrier, then it's presumed to be medically necessary. The next statute is similar to the one before this, and this one applies to certified workers' compensation healthcare networks. So 50% of injuries, new injuries in today's workers' comp world are subject to a network. So the same criteria apply on the network side, that medical services need to be consistent with the treatment guidelines and or approved through the utilization review process on the carrier side. So that comes from the Insurance Code 1305.304. 1305, that chapter in the Insurance Code, it's all about workers' compensation certified healthcare networks, and it comes from the Insurance Code versus the Labor Code. We use both in workers' compensation, both the Labor Code and the Insurance Code, specifically about the workers' comp networks here. So both the Labor Code and the Insurance Code talk about treatment guidelines. And the guidelines, that is bolded because guidelines are just that. They are guidelines, not black and white have-tos. So just keep that in mind when we say treatment guidelines, but they must be evidence-based, scientifically valid. You will find all the science behind each of the recommendations in our treatment guidelines online. Outcome focused, meaning we don't want to just provide services to your injured employees. We want the outcome to be good as it can be for that injured employee to meet the mission and goals of the workers' compensation system. They're also designed to reduce excessive or inappropriate medical care while safeguarding necessary care. That just means we want our injured employees to get the right care at the right time. And these treatment guidelines provide that structure and those scientifically valid recommendations. The official disability guidelines is the treatment guideline found in our rule 137.100. This is for non-network injuries, ODG, treatment for workers' compensation guidelines. This is the contact information. This is a commercially available product that Texas has adopted for non-network injuries. It does require a purchase. You're not required to purchase ODG, but in my opinion, you'd be operating in the dark, if you will, if you don't have ODG, because this has the presumption of medical necessity. Again, they're guidelines, and they're evidence-based, scientifically valid. If you want to purchase these, you would go and call these numbers or go to the website at that location. So this is all about non-network. At the bottom, I mentioned network claims. So those certified workers' compensation healthcare networks, the statute requires them to have evidence-based treatment guidelines also, just like the previous slides indicated. And you'll find more about that in their Rule 10.83 guidelines and protocols. The networks can have their own guideline. So you're going to have to refer to your contract. If you're a healthcare provider and you have a contract with a network, review that contract very closely. They may use ODG, they can, but they don't have to. What they have to do is have a treatment guideline in the contract. So ODG, and then whatever your network says to use. You may be signed up for multiple networks. You need to check each one of those contracts to see what treatment guideline that contract requires your healthcare provider to follow, your doctor, your physical therapist, your chiropractor, those sorts of things. So treatment guidelines are important to have and use. So just to go on a little bit more about ODG, this is an online product. It's a living, breathing document online. So things happen, things change on there. New evidence, new scientific studies are adopted by ODG and incorporated into their recommendations and their not recommended status. So if you have a book or a piece of paper, it could be outdated because this is an online commercially available product. And you can search by keywords, codes, by diagnosis that you're treating, types of treatment. There's a treatment tab and filters. They have the recommended status or not by category, body system. And then it also has all your scientific studies. I was going to flip over there just so you can see what it looks like. I've logged on to ODG here. You should be seeing the ODG webpage here. So ODG by MCG. It also has duration guidelines, meaning how long your patient on average should take off work with that type of injury. We did not adopt the duration section. That is another return to work guideline, MD guidelines. We're not talking about return to work today, but we will on boot camp day 8. This is the treatment section. This is where you can look up treatment. So if you're providing physical therapy and you're on week 12, maybe you should be taking a look at this and see if you need pre-authorization. I'll talk about how that works with our our pre-authorization steps soon. And then it has more information about costs. This is where we would focus, right in here in the treatment. So I'll click in there and you can search by recommended and not recommended. Sometimes it's recommended if certain conditions exist. This is all clinical information, and you need to know your patient and know what conditions they have if it's conditionally required or recommended. You can look up all categories of treatment and body systems. They also have tutorials here. It's very helpful to watch those tutorials. So I'm going to go back to our PowerPoint. So that's what it looks like if you had a subscription to ODG. Remember I said that ODG is a guideline. It is not prescriptive or black and white. So there is a section in ODG called Appendix D. D for documenting exceptions. So we tell our healthcare providers this is evidence-based medicine, but if your patient needs something that says that ODG says is not recommended, you can document exceptions, but your documentation and the substance behind it needs to be really good. Appendix D is going to give you some of that instruction, and it's going to document treatments that are not recommended, and it requires extensive and detailed documentation. Explain your case-specific circumstances and provide clear and reasonable documentation to justify going beyond what ODG says. So the Division of Workers' Compensation has adopted a guideline. It is just that, a guideline. You can document beyond what ODG recommends and justify that through the pre-authorization process. Also, another appendix in the ODG is the pharmacy formulary, the N status drugs, if you will. These are drugs that if you are going to prescribe them and they are listed as an N status drug, you need to get pre-authorization. N, I say, stands for needs pre-authorization. I think for ODG, it means not first line, but N for y'all, practical purposes, it needs pre-authorization. The N drug list is also found on our website. And let me go back to ODG for a minute. Back to the main page. This tab right here called the formulary is where your Appendix A is and where all of your drugs are that have statuses out to the right here. Those with the red N require pre-authorization. And you can sort different ways. The drug class, the generic name, the brand name, some other notes, but this is where you'll pay attention and where you need pre-authorization. So it goes on and on. That's under the formulary tab. You can also find it on our website. Remember our A through Z here? Not this A through Z up here. That's for TDI, Texas Department of Insurance. This is the workers' comp tab. This is our A through Z. And if you were to go to P for pharmacy, pick the pharmacy tab. This is where our Appendix A, this is all free. It's right here in this Excel spreadsheet. You can see the end status drugs on our website for free. You don't have to buy the ODG subscription to see this, but the rest of the treatment guidelines require the subscription. So that's where the Appendix A is, just to show you where Appendix D and A are, just like I showed you. The formulary is right there in that tab, and then under Help and Training, if you click on that, that's where you're going to find Appendix D. If you click on the Help and Training, you can see under Resource Library, Appendix D is right down there under Appendix B. I'll show you online. Help and Training up here. Under Resource Library, Appendix D. That is for documenting exceptions to the guidelines. We want our doctors to know that they can document and justify beyond, but be clear and explain yourself. Okay, back to the presentation. So I just gave you some pictures of where we went on the website real quick. Now let's turn to, we've talked about what is medically necessary in our system and what statutes surround that definition and the ODG treatment guidelines for non-network healthcare. Again, for networks, check your contract to see what guideline, what treatment guideline they use. Some of them may use ODG. So let's talk about non-network and what medical services need pre-authorization. So for the non-network injuries, that should be part of your intake and registration, is to find out if that claim, that injury, if you will, is subject to a network or not. If it's not subject to a network, it's called non-network medical services. And when you're looking at what services need pre-authorization in the non-network world, you would turn to Rule or Texas Administrative Code, TAC, Section 134-600. That's called pre-authorization, concurrent review, and voluntary certification of healthcare. I'm going to call this the non-network pre-auth rule. If you read that rule, it's got several pages to it, so make sure you go to the bottom and hit the next page when you're looking on our website under R for rules, and you can go to chapter 134 and see chapter specific rule 134.600. In that rule, if you're following the organization outline of that rule, you go to P, lowercase p, and there's going to be a list of services 1 through 12. All of these that it talks about are requiring pre-authorization. In the P1 through 12, it includes treatments and services that ODG does not recommend or address. So you got to look at your list, and then you got to check ODG for that service to see if ODG does not recommend that spinal fusion or that pain pump or that whatever you're providing to our injured employee. And if you need to document exceptions, use Appendix D. Also, the drugs not included in the pharmacy formulary, the end status drugs, are going to require pre-authorization. And notice that it says list of non-emergency services. And at the bottom, it says office visits do not require pre-auth. So the exceptions are emergency. If your patient is in an emergency, they can go to the ER. It does not require pre-authorization. Office visits do not require pre-authorization. However, they can be looked at retrospectively for medical necessity, but they do not require pre-authorization up front. So your list of P1 through 12 is going to tell you for non-network what services need pre-authorization. Here's a decision tree for your staff in the pre-auth department. These are typical non-network treatment and pre-auth decisions. However, you could probably use this for network decisions and just insert their treatment guideline for that network. But the first question is the treatment you're providing or the drug list on the list P1 through 12? If it's yes, then you need to request pre-authorization. Always support every service you provide with documentation. If it's no, does ODG recommend that treatment? If they do, then you don't need pre-auth and it's subject to retrospective review. If the ODG does not recommend that treatment, then you need to request pre-authorization or document exceptions if it's an exception to the ODG there. So it's just a decision tree for your staff, graphical illustration here for you. What network services? Those are injuries that are subject to a healthcare provider, certified healthcare network. What services need pre-authorization if you're dealing with a network claim? You have to look at your contract. So medical services outlined in the contract between the network and the healthcare provider. So check your contract to determine what services need pre-auth and how to do it. Also, drugs not included in the division's pharmacy formulary. The end status drugs are for both network and non-network. So the end status drugs apply in both scenarios, both types of injuries. And to talk more carefully about the pharmacy pre-authorization requirements and how the pharmacy formulary works, you'll see that in list the P1 through 12, it's number 11 in the list, drugs not included in the formulary. So our formulary for both network and non-network is all FDA drugs, all FDA approved drugs are in our closed formulary. The ones that come out are exceptions and need to have pre-authorization. And those are drugs with the end status that's found in Appendix A, any investigational or experimental drugs, and all prescription drugs created through compounding. It doesn't matter if the compounded ingredients are not on the end list, just because they are compounded, they need pre-authorization. So just to get that clarified, all the ones in that box need pre-authorization. The rest of the FDA approved drugs are within our closed formulary and do not need pre-authorization. So check your end status. If it's investigational, experimental, or if you're compounding it, it's going to need pre-authorization. And I'll just have to stay here. The prescriber, meaning the doctor writing the script for that medication, is the best person to request pre-authorization. The rule doesn't say he or she has to, but they are the best. The pharmacy will be asking you for information if they have to do the pre-authorization, or the injured employee for that matter. The prescriber is the best person. They have the justification for that pre-authorization. So once you ask for pre-authorization, what is utilization review? Let's go through the regulation that covers utilization review in our workers' compensation system. For network injuries, these are the citations that cover utilization review for certified workers' compensation network claims. The insurance code in 1305, we've talked about that covers all things workers' compensation healthcare networks. Also, section 4201 from the insurance code, we license utilization review agents and certify them at the Texas Department of Insurance. So section 4201 from the insurance code covers how URAs get licensed and what regulations we have set for them. So those are the two statutes. Now we'll talk about the actual rules. We write the administrative code at the TDI. And in part 1, chapter 19, that covers the licensing and regulation of insurance professionals. That's important in utilization review. And then subchapter U covers utilization review specifically for workers' compensation. This is all coming from part 1 of the insurance code and the related Texas administrative code. Chapter 10 is workers' compensation healthcare networks. Subchapter F within that is utilization review and retrospective review for networks. So if you want to, or you're involved in a situation where you need to research the utilization review for a network claim, this is where you're going to go. We have the locations on the DWC Finding Your Resources if you need to do that, and find it on the TDI side of our website. Now the regulations surrounding non-network claims. Insurance Code 4201 covering utilization review agents also applies for utilization review agents working on non-network claims. Also, Chapter 19 applies to the licensing and regulation of insurance professionals, also applies to non-network. Subchapter U, utilization reviews. And then in Part 2 of the Administrative Code, which is all the workers' comp rules. Now, we use Part 1 and Part 2. The Insurance Code and Labor Code work together here. But Part 2 is our Administrative Code for workers' comp. You'll find the 134-600 in Chapter 134 and Subchapter G. We've been talking about that rule. What is utilization review? That's when the insurance carrier's URA, utilization review agent, looks at the service for medical necessity and appropriateness. It is only a certified utilization review agent that conducts this type of review for medical necessity. The insurance code, remember I said 4201 governs the certification of those utilization review agents. And they sometimes have different names than from the insurance carrier and from the network. Some of them have their own names. The insurance carrier is contracting the utilization review through these URAs. And now Texas Department of Insurance certifies URAs to operate in our system. So only certified utilization review agents can make medical necessity decisions through utilization review. Adjusters or employers or anyone else that's not certified as a URA, they may not conduct utilization review. So make sure you hear me on that. Adjusters may not make medical necessity decisions. Only certified and registered URAs with the Texas Department of Insurance can conduct utilization review and make medical necessity decisions. Employers can't either, unless an adjuster or an employer happens to be certified as a URA, but that probably is unlikely. So just so you get that, only certified URAs can make those decisions. In Section 28 TAC, Section 180.1, we have a definition section in our rules, Part 2 of the rules, and it says a physician performing utilization review as part of that URA must hold appropriate credentials. They have to be of same or similar specialty as the physician who's requesting the pre-auth for that service, and they must also have a Texas license to practice in Texas to be able to conduct utilization review. If you're a dentist or chiropractor out there, dentists and chiropractors must also be appropriately licensed if they're working for the utilization review. So we had a lot of feedback about this. We wanted to make sure that it's same or similar specialty. So the reviewer on the URA side has to have the same or similar specialty as the person that's prescribing that service and requesting pre-authorization, or even on a retrospective basis. And this change on the same or similar specialty was effective February of 21. If during utilization review, you receive a denial, we also call those adverse determination. That means that the medical services that you proposed or provided, if it's retrospectively, are not medically necessary or appropriate. So the utilization review is certified to do that with the same or similar specialty provider, and they say, no, we don't think this is medically necessary. That's called an adverse determination. Adverse determinations do not include a denial for if you're a healthcare provider, failure to request pre-auth. So say you have a service that needed pre-authorization and you didn't get it. The insurance carrier can deny you for just not getting it. They're not saying it's not medically necessary. It's an administrative denial saying you should have gotten pre-auth and you didn't, so we're going to deny you. So you need to know when you need pre-authorization. So adverse determinations are not saying, that are all about medical necessity. If you don't get pre-auth and you get denied, that's an administrative denial. Let's go through the non-network preauthorization process. 134-600, we talked about that rule, the non-network preauth rule. It's a long name, so I call it the non-network preauthorization rule. The requester or the injured employee, when they're making a request, their very first request to the URA, to the utilization review agent. So in your pre-auth department, you need to know who the URA is so you can get that request directly to them. They should include on that first request the name of the injured employee, the specific health care that you're proposing to provide. You don't necessarily need CPT or HCPCS codes. You can include them if you want. It doesn't say one way or the other, but you need to tell us what specific health care you're proposing to provide, the number of treatments, a specific time frame to complete them. Be very, very careful with what you're saying here. You need to be able to get that service done within that time frame. And information, most importantly, information to substantiate medical necessity. Use your treatment guidelines. Use the regulations in the first few slides to help you justify and document medical necessity for that drug, the end status drug, or for that service, or for that surgery. There is no specific DWC pre-authorization form. So if you're looking for one on our website, it doesn't exist. Some healthcare provider clinics have their own form to request pre-authorization, but know these items need to be on your initial request. It should include a phone number and fax number for the URA to contact you, and the name of the requester and professional license number of that requester and their NPI number. Now, or the name of the employee if the injured employee is requesting pre-authorization. Hopefully it's going to be you, the prescriber that's requesting pre-authorization. An injured employee can do it, but they're at a disadvantage without the medical necessity justification and documentation from you. The name, license number, or NPI of the healthcare provider that's going to render that service if it's different. So the requester's information and then the person that's going to render the service. Also, if the service you're providing and requesting pre-authorization for is going to be done while your patient's in a facility, give us the name of that facility and their NPI and the estimated date of the proposed healthcare. Pay attention to that. Keep that in mind as you're going through the pre-authorization steps. We don't want to get outside of that proposed date without adjusting it. So you've requested. All of that information was provided on your initial request, most importantly, substantiating the medical necessity of the service you're going to provide or that drug. The URA is going to respond to that pre-authorization request. They must either approve or issue a denial within 3 working days of receiving the request. 3 working days means if you request on Friday, day 1 will be Monday, day 2, Tuesday, day 3, Wednesday. So if I requested today and today's Tuesday, day 1 will be Wednesday, next day. So 3 working days. It is not 72 hours. It is 3 working days. Also, the utilization review must send a written notification within 1 working day of that decision to the injured employee or their representative and the requester. So that's the responsibility. We'll walk through the URA's responsibilities now. The URA must approve or issue a denial based solely on medical necessity. That's regardless of any unresolved issues of compensability, extent, relatedness. Remember, the URA should be opining or giving their opinion on medical necessity, regardless if there's an extent of injury issue outstanding. So again, solely on medical necessity, a yes or no. Those are 2 different issues. Medical necessity is not the same as extent of injury. Medical necessity is just that. They could say, yeah, Amy Rich needs that back surgery. And then they can say at the bottom, but we don't think the condition you're treating is part of the compensable injury. Again, two different things. Make sure you know that the URA should be giving you an opinion on medical necessity. And regardless of the insurance carrier's liability for the injury, that URA needs to respond within the 3 days, or the fact that the injured employee has reached maximum medical improvement. We all know if someone reaches MMI date, meaning the doctor's saying is this person, Amy Rich, is as good as they're going to get, they still can have medical services after the MMI date. And some of those services may require pre-authorization. So the URA has a responsibility to issue an opinion on medical necessity. And when they respond, it should include, the response should include the specific healthcare. So you're communicating to them the specific healthcare, and they're communicating back to you what they approved, the specific healthcare they approved, the number of healthcare treatments and specific time frame to complete those treatments. And also, like I said, at the very bottom, they have to let you know if there's any outstanding or unresolved disputes regarding compensability, liability, extent, or relatedness. Those are different from medical necessity. They have to tell you whether they think it's medically necessary or not, and then give you information on that pre-auth approval, whether there's outstanding unresolved disputes there. So you as the healthcare provider should have everything you need to know at that point on how to proceed. And the pre-authorization approval number, of course, comes on that response. It goes on your bill also. So if you're in the pre-auth department, check your approvals very carefully. Check your approvals very carefully, looking for any unresolved disputes or outstanding disputes on extent of injury or relatedness. Can the URA, once they issue that approval, can they withdraw that request after they said it was medically necessary and then they want to take it back? Or can they change the elements of the pre-auth request? So once they've pre-authorized, the approval must not be withdrawn by the URA. So they can't take another bite at the apple. If they say it's medically necessary, then they may not withdraw it. And here's the other part. The URA cannot condition or change any of your elements of your initial request unless they've talked to you and you mutually agree upon in writing to change it. Let me give you, for instance, if you ask for 12 weeks of physical therapy and the URA calls you and says, we don't think 12 weeks is recommended. We don't think it's medically necessary. And here are the reasons why. We think only 3 weeks of physical therapy. If you both agree, then they can change it, but they cannot change any of your initial elements without mutual agreement and in writing. So it's a yes or no to what you requested, or they get your agreement to change it. We get this question a lot. And I hear from healthcare providers that says, I got pre-authorization. Why am I getting denied? Does pre-authorization guarantee payment? And I'm going to say yes and no. Once you've got pre-authorization, that means they say the URA is saying it's medically necessary. So the carrier may not deny your medical bill for medical necessity because they've already said it was medically necessary. Again, not a second bite at the apple. So it does guarantee you that. That's a yes part. The no part is a carrier can deny you for other reasons. The other reasons, like extent of injury, that's not the same thing as medical necessity. They can deny you for compensability, extent, or relatedness, even if you got pre-authorization. They also can reduce or deny based on your billing and coding issues. Make sure you have a good biller and coder to assign those CPT codes and HCPCS codes to your medical bill. And you know your CCI edits, just like we talked about in day 4 and 5 of our bootcamp series. And so 413.014, that section of the labor code says that an insurance carrier may not deny for medical necessity if they've already pre-authorized. If the initial utilization review agent response to your initial request for pre-auth is an adverse determination or a denial. You can find information about that in Chapter 19, 2003, definitions. An adverse determination is a URA saying that that medical service that was provided on a retrospective review or proposed to be provided in a pre-auth request is not medically necessary or appropriate. So that's what an adverse determination. It does not include a denial for medical services due to the failure to request pre-auth. Remember, it's not the administrative denial. That's something separate. This is saying they're making a decision that they don't think it's medically necessary. It's also not a determination that the medical services are experimental or investigational. And the URA has to put together their adverse determination with certain elements. It must contain the principal reasons why they think it's not medically necessary and why they issued that adverse determination. What are the principal reasons and what is the clinical basis behind their decision? Remember, we've got a similar specialty provider on the other end at the URA with a Texas license. They have to give the principal reasons and the clinical basis and a description for filing a complaint with us, the TDI, if you determine you need to file a complaint, and the information about the professional specialty and the license number of that provider on the other end that made the adverse determination. So this should be coming to you after you've requested pre-auth if they're going to deny. It also must contain the procedure for the URA's complaint and appeal system. That includes the LHL Life Health Licensing Form 009. That is the appeal form. So they're going to give you that in their adverse determination. And the source of the screening criteria or treatment guideline used. Remember, for those networks, they're going to have their own treatment guideline. For non-networks, it should be the ODG, and they should be taking out what they used to support their adverse determination. So read those adverse determinations really well. Let your provider look at that so that he or she can do his appeal effectively. If the pre-authorization denial or adverse determination is based on a peer review report, so that insurance company has asked a peer to review medical records for this claim. Peer review reports used to deny a pre-auth request must document the objective findings and evidence-based medicines that support that opinion in the peer review, including the peer review's name and Texas license, their qualifications, a list of all the records and documents reviewed. So pay attention to that because maybe they're missing an MRI image. Maybe they're missing some physical therapy that you had or some other document. They're supposed to list every medical record that they looked at and documents reviewed to make that peer review decision, a summary of the clinical history, and an explanation of that peer review decision. So if in your adverse determination they said, we use this peer review, that peer review should have all these elements in it. Now, in our rule 133.308, if there's a medical dispute resolution on a medical necessity denial, it says that the insurance carrier's use of a peer review report that's gone all the way through an IRO, and that IRO decision, IRO's independent review organization, if the IRO overturns that insurance carrier's denial, where they use the peer review, the carrier cannot use that peer review to support other medical necessity adverse determinations for the same medical service. So once it's been overturned by an IRO, the carrier can't use it again for the same medical service. So I hope that makes sense. They can use peer reviews for their adverse determination, but if you've appealed it all the way through an IRO and it's been overturned, you won at the IRO, that peer review can't be used again for the same medical service. On that note, can the insurance carrier deny all future medical care? According to our labor code 415.002, which is a list of administrative violations by the insurance carrier, it says that an insurance carrier or its representative commits an administrative violation if they make a statement denying all future medical care. You might see this on reports or EOBs or statements from an adjuster that says, this person, Amy Rich, is completely cured, does not need anything else in the future. That might be an administrative violation of 415.002. So know that that exists, and every medical service needs to be looked at on its own merit for medical necessity for that injured employee at that moment in time. So they can't make blanket statements denying all future medical care. Back to the adverse determination. Before the URA issues that adverse determination, there must be an effort to have this conversation, this peer-to-peer, you call it peer-to-peer conversation. So they've got the peer, same or similar specialty on the URA side, and you've got your person who's prescribed that service. The URA must afford that healthcare provider a reasonable opportunity to discuss the plan of treatment for that injured employee, and provide the URA's telephone number. They must document, the URA must document a good faith attempt for that peer-to-peer conversation to discuss those services that are being looked at by the URA. It has to be during normal business hours before issuing a pre-auth adverse determination, no less than 1 working day before they issue that pre-auth decision of a denial. So if you feel like your URA has not afforded you a reasonable opportunity to discuss this, you can file a complaint with us. So go to C for complaints on our website, but it should be no less than 1 working day before the final adverse determination, that discussion. We want you to have that discussion to see if the adverse determination can be worked out during that conversation. It needs to be meaningful. The discussion must include, at minimum, the clinical basis for the URA's position and a description of the documentation or evidence that the healthcare provider can submit to change their mind. Maybe they're missing that MRI report or something. So during that conversation, we want it to be meaningful. They have to tell you the information they've used to make a medical necessity, or that they're going to make a medical necessity decision that's a denial. Tell you what they need if you can submit something that changes their outcome. So that's during the conversation. If that doesn't work, you can appeal the adverse determination during a request for reconsideration. This is a formal process by which the healthcare provider of record, we can call those requesters, or the injured employee can ask for an appeal of the initial adverse determination. The appeal must be done either in writing or it can be done orally. And you have to do it within 30 days of receipt or 30 days after the date of the denial for network. You see that nuance there. Basically, 30 days after you've received that adverse determination, you need to do an appeal if you're going to pursue it. Some people, some healthcare providers turn everything over to the injured employee at this point and say, I've asked once, I've gotten an adverse determination, and turn it over to the injured employee rep. I'll tell you that the injured employee is at a disadvantage because they don't have the medical necessity information to appeal. You do. You wrote the prescription for that service, but the injured employee can pursue this. Some people do that thinking that that would avoid an IRO fee, if you will. We're going to go over that later in the presentation, but you do not have IRO fees if you're appealing an adverse determination. So let's go on. Your requester's appeal of an adverse determination, we call that RFR, request for reconsideration. You need to address the reasons for the denial in your request by considering all the things we talked about at the beginning of the presentation. What is the definition of medical necessity? Does your service meet that definition? Does it cure and relieve the effects of that condition? Does it help somebody get back to work? Document that. The applicable treatment guidelines or screening criteria. Document exceptions if you're going beyond what ODG recommends or what the network treatment guidelines say. And any information that may be missing, include that in your request for reconsideration. Do not miss your deadlines. It is very difficult to overcome a missed deadline in the pre-authorization process. Please know your deadlines. If you miss it, it is very hard to start over, if not impossible. The URA, once they get your appeal for request for reconsideration, they must respond to that appeal as soon as practicable. Love that word, but not later than the 30th day after receiving the appeal, which is also called the request for reconsideration. So you have 30 days, they have 30 days, and then when 3 days after receipt for a concurrent utilization review. So those of you out there in the hospital setting, or maybe in a physical therapy setting where a person got the initial pre-auth for the initial services, but the pre-auth has ended, you need to ask for concurrent review. They have to respond within 3 working days if you're appealing that adverse determination during a concurrent utilization review request. You can find all of that in 134.600 Q1. If the URA's response to the appeal or request for reconsideration remains an adverse determination, so that's their second no. So if the first is a no, you ask for appeal. The second request appeal is a no. You may request an IRO, you, the requester, may request an independent review organization to review it. That is another organization that is not run by the carrier. We have several of them that we can assign these to, but your timeframes to request an IRO, you need to know the timeframes. Do not miss them. It's non-network, no later than the 45th day after the receipt of the second denial. And for network, it's not later than the 45th day after the date on that denial. Again, a little bit of nuance between network and non-network, but basically 45 days, you need to ask for an IRO, because if the request dies because you missed a deadline, it is very, very difficult, if not impossible, to restart a pre-auth request. In fact, resubmission of a pre-authorization request for the same exact service, if you're going to try to start over, you have to show that there's been a substantial change in that patient's condition, or maybe say you ask for a spine surgery and the carrier's URA says, have you gotten a psychological evaluation of this patient? Because that's a condition listed in the ODG. I don't know if it's there now, but you have to use your ODG to find out. There are sometimes clinical prerequisites that need to be in place before you proceed with a surgery, say. So if you've gone back and gotten that psych eval for the injured employee, then you may have met your clinical prerequisites and you can start over with your pre-auth request. But those are the only 2 circumstances where you can start over. So do not miss your deadlines. Here is the pre-auth steps for non-network. All the things we've been talking about. The first column is your initial pre-auth request. Second one is your appeal or request for reconsideration. And then the IRO deadlines. So all the deadlines and the citations are in here for non-network. And here is your flow chart for network pre-authorization and concurrent review processes. Use those, print those out. They are on our website also that you can look at any time. Make sure your pre-authorization department has these so they can follow along and not miss your deadlines. And also, your pre-auth department needs to be trained up on the treatment guidelines and substantiating and documenting a request for medical necessity. Say you're getting to the IRO process. You've gone through your initial request, your request for reconsideration or appeal. Then you're going to request an IRO. The form that the URA should be providing to you is an LHL Form 009. This can also be found on our website. Look under F for forms. This is the request for an IRO. You may be helping an injured employee fill this out or filling it out yourselves, the instructions are at the top of the form. Most of our forms have instructions on the last page. This one happens to have it on the front page, but either way, most of our forms and notices have instructions on them. Do not send this form to us at Texas Department of Insurance. This goes right back to the URA. So you've asked them the first time, they denied. You've asked them the second time, they've denied. Then you fill out the LHL 009 and you send it right back to the URA. If you have questions about filling out this form, you can call Texas Department of Insurance, Managed Care, Quality Assurance, or the MCQA department at this telephone number or the toll-free number, or email mcqa@tdi.texas.gov. A little bit of tips for this form. The denied services section, right there, that blue highlight at the very end of the form. This is information on the denied healthcare services, on the denial from the insurance carrier. It doesn't necessarily have to be CPT codes or HCPCS codes. You can quote what's in the adverse determination or your initial request for preauthorization. The patient and injured employee information. If you don't know our Division of Workers' Compensation claim number, it's okay to leave that part blank. The federal tax identification number for, if you don't have it, you don't have to place it on that for the provider, and only complete Part B if it's different from Part A. So know that if you have any questions, you have the contact numbers there. And the last section, for workers' compensation, HIPAA does not apply, so a release signature is not required for workers' compensation cases. The bottom part is to be filled out by the utilization review agent. And the URA includes the LHL form. So like I said, the adverse determination should have an LHL form or a way to get to the LHL form, or you can find it on our website. It is to be mailed or faxed back to the URA within 45 days of the second denial. Just keep in mind that nuance between network and non-network. And then the URA turns around and submits it to us, and we select the independent review organization. Here is the IRO process flow chart. So once the IRO has been selected, these are the steps that it goes through to issue a decision. On the right, that orange box is the information about the IRO's decision, and then appealing the IRO decision and the citation. So if you need more information about that, check out 28 Tech 133.308. That's a citation there. Back to the IRO fees. Some of you may have a misconception about fees for the IRO, and that's why some of you may turn over the appeal process to the injured employee. I can tell you, injured employees at a little bit of a disadvantage. They're not the doctor. They're not the physical therapist. They don't have that information to substantiate. Just know this: for all pre-authorization IRO reviews, the carrier is paying the fee for all pre-auth, whether it's network or not. So you're not avoiding a fee if you appeal to an IRO. There is no fee for you, healthcare provider. The insurance carrier also pays for network retrospective reviews. That's for services that didn't require pre-auth, but are looked at on the back end. And the insurance carrier pays for all retrospective reviews requested by the injured employee. So most of the time, the insurance carrier is paying the IRO fee. The only time that the requester may have to pay the IRO fee up front, but if you win, you get it back, is on non-network retrospective reviews. For instance, an office visit does not require pre-auth, but the carrier can look at medical necessity through their URA retrospectively, and you want to appeal that denial, you would have to pay the IRO fee up front. If you win, you get it back and you get payment for that bill if it's billed appropriately and there's no CEL or compensable extent relatedness liability. So you would have to front that IRO fee. If you lose the IRO. How do you appeal an IRO decision? Remember, I said 133.308 outlines the appeal of an IRO decision. It happens in our contested case hearing department, our hearings department. A CCH is held on appeals of an IRO decision. That means an administrative law judge is going to be looking at all evidence submitted during the contested case hearing. There is probably a deadline to file for that contested case hearing. That's going to be explained to you in your IRO decision. Also, the IRO decision is not an agency decision. They're an independent review organization. We, the division, is not considered a party to that appeal. And BRCs are not a prerequisite to a CCH. So you can go straight to a CCH if you're appealing an IRO decision. First responders that have gone through all of these steps and are appealing the IRO decision, those requests for a CCH can be expedited. So they can move to the front of the line. The IRO itself and their staff are not required to participate in the contested case hearing. The appealing party, so if you're the doctor that's gone all the way to the IRO, and every step of the way the carrier has said, no, we don't think it's medically necessary, you have the burden of proof of overcoming that decision of the URA and the IRO with a preponderance of evidence-based medical information. So anybody appealing has the burden of proof to overcome all the decisions that have been made before that. So substantiating medical evidence, having your scientific studies ready to present. But I'll tell you this, my advice is to get it right on the first initial pre-auth request and have it all ready if you have to go all the way to a CCH. And before the CCH, a party may send a letter of clarification to the chief clerk, but it may not ask the IRO to reconsider its decision. So you may ask for clarification of that IRO decision before the CCH, but you can't ask it to change its mind or reconsider its decision. The administrative law judge or the ALJ will consider the applicable treatment guidelines. So the ODG, or if it's network, whatever the network treatment guideline is during that appeal of an IRO decision. What happens after the hearings process? If a party would like to appeal after all administrative remedies are exhausted here at the division, they may pursue judicial review outside of the Division of Workers' Compensation. We're not a party to that appeal, and we may charge expenses for the requester for preparing documents for that judicial review. So it goes on and on. Can a healthcare provider bill the injured employee after decision on medical necessity? So let's say you get all the way to a CCH and it becomes final and you do not appeal it to the next level, or maybe you've missed a deadline for the second adverse determination, so the pre-auth request dies. Can you just turn around and bill the patient? Say you ask for pre-auth, you get an adverse determination, you're like, I'll just forget workers' comp and bill the patient. Is that allowed? The answer is no. Labor Code 413.042, private claims, administrative violation. If you pursue, meaning bill the patient for the services, for all or part of that medical service, you may be in violation of this statute. The only time you can turn around and bill the patient and pursue payment is if the injury itself has been adjudicated as not compensable. They say, they being us, the Division of Workers' Comp says this injury was never work-related, or that diagnosis was never part of the accepted compensable injury. That's when you may pursue a private claim, meaning bill the patient or bill their Blue Cross, bill their whoever, Medicare, Medicaid. This is why I tell you not to miss any of the deadlines for pre-authorization, because if you go through all of that and it's a final decision, or you missed a deadline and it's not medically necessary, you may not bill the patient for it or pursue payment. So services determined not to be medically necessary is not the same thing as an injury adjudicated as not compensable. In that scenario, you can bill patient if it's final. So heads up, don't miss your deadlines. and you may not pursue a private claim. The takeaways we want you to know about here in this presentation is you may not bill the injured employee. You may only be able to resubmit the same pre-authorization in only very limited circumstances. I told you about them on that one slide. The patient has to have a significant change in their condition or some clinical prerequisites need to be obtained. What you need to know is the definition of medical necessity in those first few slides, the treatment guideline and screening criteria, how to document exceptions, if applicable, and any information that may be missing to help the URA make a decision and know your deadlines. The overview of what we've covered today is medical necessity and workers' compensation, medical services requiring pre-auth, what is the UR process, the utilization review process, the IRO process, and your resources. And now we're going to see if we trained your brain. We want y'all all to flex with your polling questions and see if you were able to understand some of the things we wanted to transfer over to you. The first question is, can an adjuster or an employer conduct utilization review and make a medical necessity decision? The answer is no. Unless they're certified as a utilization review agent, they may not make medical necessity decisions. Number two, what non-network medical services require pre-authorization? Rule 134.600 P1 through 12 is the answer. Thank you for participating in that one. Number three, is a denial for medical necessity the same as a denial for extent of injury? The answer is no. Those are two different defenses that a carrier will be looking at when you submit your medical bill. They are not the same type of denial. Do emergency services or office visits require pre-authorization? The answer is no, but they are subject to retrospective review by the insurance carrier's URA, utilization review agent. Number five, if your pre-authorization request is denied, you can just bill the injured employee for the services. The answer is no. Everybody got that one right. I appreciate that. Next time on our boot camp, we hopefully did not fall through all of those pitfalls in your climbing net, and we will get to the climbing wall, if you will. That's our next obstacle course challenge. And it's about certified workers' compensation healthcare networks. And our learning objectives to get over that wall is to learn what is a certified workers' compensation healthcare network and know how to find networks in your clinic's area and how to apply to become a network provider. Also, to understand the importance of registration and intake and identifying your claimant's network status. So those are our learning objectives to get over that wall for your next boot camp. You can always contact us at Comp Connection 800-252-7031, option 3, or email us at compconnection@tdi.texas.gov.